Good afternoon, everyone. This is Zach Lucas from McCarthy Betting. Just going to start a little bit earlier than scheduled, just to begin the sort of pleasantries and to introduce the panelists and to go through today's agenda on the last virtual roundtable of 2020. So if I track through, here's the panelists for today. So I'll start off with Marcus Hinckley. He's head of private clients in Asia for Hawksford, which is a corporate service provider and also a trust company in Singapore. And then we're joined by two bots from 1291. First, obviously, Peter Triggs, who is probably widely known to the Singapore market, and Yannick Honey from the Hong Kong office of 1291, CEO of Asia Group. And we're also happily be joined by Michael Velton, tax partner with Deloitte in Singapore. So these are the main panelists. And I think just before we get started, I'll do the normal admonitions, which is when it comes to these virtual roundtables, we obviously are running through technical discussion points. Today is a quite topical one because it deals with PPLI versus trusts. There are many, many technical points that will come up in practice in this. These are sort of sincere views of all of the practitioners involved, but they shouldn't be relied on as constituting any form of legal advice. So we don't want to be in a position where anyone is using the comments that are made on this particular webinar as a basis for advice or basis for action or inaction. So these are just general comments being made by practitioners for the benefit of the viewers, but without incurring any sort of liability risks. For today's purposes, I'll run through the agenda. So we'll do a general introduction. Here we'll do the comparison, or the high-level comparison between PPLIs and trusts. We'll look at the life cycle of each of these platforms, and we'll look at obviously the creation, the administration, the termination of each of them comparatively, and then look at combination solutions where a trust is combined with PPLI and analyze which seems to be the most compelling combination. Then we'll end with the question and answers. Now, as with always, after the event, a recording as well as the slides will be circulated so that if in case you need to drop off or indeed you're watching it later, then that's all fine. So introduction, going through just the basic component parts of the trust as against the PPLI, and then all the life cycle comparisons. So kicking off with, we'll use the trust first because it's, I suspect, quite familiar to many of the viewers today. And what we'll do is we'll go through the component parts and I'll invite Marcus to have some comments, and we'll just talk generally about the component issues on a trust and how they all configure together. So the first thing is the set law of a trust. You always need to have an individual or an entity creating a trust. And I'd ask Marcus, in your practice, when it comes to trust creation in Asia particularly, is it predominantly individuals, or do we see a lot of corporates creating trusts? Typically within, let's say, the Singapore market, which is one that you're more familiar with?
Well, certainly the individual trustee, individual set laws is by far and away the most common. It's not to say that companies, corporations don't set up trusts at all. There are various reasons why that might happen, but generally speaking, it's individuals.
In terms of reserved powers or power holding positions within the trust context, obviously this is a very, very sort of necessary component part, particularly within the Asia market. It's a way in which you balance the trustees' unbridled discretions and you provide some level of take back for the family or for the settlor, and usually these are described as protectors. Now, Marcus, in your experience, when it comes to protectors, is it generally just the settlor is the reserve power holder, or do we have sophistication in the market where it's a group or a committee-based protectorship? What do you generally see?
I think that in the more simple cases, you'll see a reserve powers trust, and the settlor will have those reserve powers back to himself, the rights and obligations. In more complicated, particularly if we're dealing with family succession or family governance kind of issues, you might see protector committees, for example, formed. So in the more complicated ones, you're seeing more and more of that. And as the advisors are becoming more familiar with how to draft it and how to use it, I think we're seeing a greater use of committees in the market.
What sort of powers are generally reserved? So what is this split between the trustee and the protector? What is actually going on there in terms of the typical powers that are reserved?
So to a certain extent, that depends on the law that you're looking at. So if we're talking about strict reserve powers, under reserve powers laws in Singapore, Hong Kong, the reserve powers are the power of investment. And almost inevitably in any jurisdiction, a client is interested in reserving to himself that power over the buying and selling of his trust assets. However, you can of course reserve other powers to yourself as well. So either if you're using other jurisdictions, Jersey, for example, you can reserve other powers of disposition over the trust assets, etc.
So the idea with these power holders is to provide some form of balance within the trust. The trustee has some discretions, but there's also some discretions that are reserved to the family. Is that basically what's going on?
Yeah. So really, I guess initially the trust tool was a trustee-directed kind of vehicle where the settlor wouldn't have any ongoing obligations and ongoing rights. But you know, from a marketing perspective, that's a very difficult thing to sell to a lot of people, particularly those who are not from a common law background. So providing a structure whereby they can have a lot more control over what the trustee is doing is something which is far more sought after.
Right. And just moving on to the trustees, obviously we can have different types of trustees. We can obviously engage licensed trustees like Oxford, for instance, but we can also have PTC or private trust companies, as well as individual trustees, which is fairly rare, I would have thought, but there are also a possibility. Generally in the market space, what do we see? Is it mostly PTC trustees, or are we starting to see actual individual trustees starting to turn up?
Well, we do get called about all three of those possibilities. So
Right.
obviously, there's no place for a professional trustee if in the end of the day it's an individual trustees who, you know, the individuals want to be trustees themselves. You know, in places like New Zealand, Australia, very common indeed to be a trustee of your own trust. So, but it's in these professional trustee environments where really the companies, the licensed trustees have kind of taken over. And then you've got the PTCs. So PTCs have come in as a way of allowing that the family, if you like, or the settlor, let's say, direct control over the trustee. He is now sitting on the board of that PTC, private trust company.
As far as you have licensed as against a sort of PTC, what's the ratio? Is it like for every one licensed sort of trustee trust, you have two PTCs, or how does that look nowadays in terms of the PTC usage?
Yeah, that very much depends on the type of book you've got. So the PTC comes into its own where you're dealing with perhaps family-owned businesses, where people really want to control their own destiny, or they're dealing with trading assets perhaps that the trustee is reluctant to hold themselves. So if you're a trustee that only holds bankable assets, for example, you probably very rarely see a PTC. But if you are a trustee that's dealing quite often with interesting assets, you know, luxury art or trading assets, things like this, you might see PTCs quite often. In Hawksford, our ratio is about 1 in 15, I suppose. 1 in 20 would be a PTC.
Really? Okay. In terms of beneficiaries, obviously these are traditionally going to be family members. How many times do you actually corporate entities being beneficiaries, or does it just tend to be natural persons?
It tends to be natural persons.
Right. And in terms of, are they described individually typically, or are they described as a class?
So you will probably have a combination of that. So the primary beneficiaries, those who are alive right now in the lifetime, that might be the settlor, his wife, for example, immediate family. You will probably see them described individually. But as you go down generations, you're likely to see that a class of beneficiaries are mentioned. You know, the grandchildren of the settlor or something like that.
Okay, so those are the main constituent sort of parts of the trust, and obviously the underlying entity here, it's showing shares in a company that holds bankable investments. That's the trust fund, but these are the main parties to the trust: protector, settlor, trustee, and then beneficiaries. Now, from a PPLI policy perspective, here's the interesting aspect. So we've described it in the diagram as a PPLI policy holding the shares of an underlying company with an investable account. In reality, this is for shorthand, in reality, it's the life company that actually holds that underlying company. It's not the policy as such, because the policy is a contractual document. But for shorthand, we've kept it as the policy visually holding the underlying company. So policyholder, so I'd probably invite Peter to have a canter at this one. Policyholder, can you explain for the members that are watching this, what is a policyholder in the context of a life product, such as a PPLI policy?
Sure, happy to do that, Zach. But if I may, I'll just take a minute because I think private placement life insurance might be a little new to some of the people dialing in. So just a minute or so of background. Private placement life insurance has been around for a long time in the US and also in Europe. And it has been in Asia as well for a while, with companies like the Prudential, for example. And there's a number of companies here, Friends Provident, there's quite a few. And they will typically have their own sort of products, which will be private placement life insurance products. And typically these have become known a little bit as either wrappers or 101 policies with perhaps 1% of life cover, 100% being the assets that are put into them. So they qualify as an insurance contract. And I think some people in Asia perhaps think that PPLI is the same thing as a 101 policy, whereas PPLI is a much broader concept. The 101 is a subset, just as variable universal life is actually a subset of the broader concept of PPLI. And so it's the broader concept that we're talking about today, the idea that you can transfer your assets into the name of an insurance company in the same way that with a trust, you transfer your assets into the name of a trust company. And you'll find that during the presentation that Zach's put together here, we're looking at a particular situation where the asset is an underlying company. And we're using that to demonstrate the analogies, the similarities and the differences between the PPLI as an asset holding structure and the trust or trustee as the asset holding entity. So back to your question, Zach, what's the policy holder? The policy holder is sort of analogous to usually the settlor. The settlor transfers his assets to the name of a trustee and gets back, if you like, the trust deed as the sort of the reference document to govern the relationship. The policyholder is the original owner of the assets, typically, who has transferred the assets into the name of an insurance company, but the governing document is an insurance contract. And the policyholder now has an insurance contract giving him policyholder rights, which typically is the right to redeem or partially redeem the policy at any time, and the right also to assign the policy to another policyholder should he so wish. So it's analogous, if you like, to the settlor of a trust.
And the relationship between the policyholder and the insured, there's a terminology here of an insurable interest. Now, I know in some instances, some jurisdictions don't have that concept. Common law jurisdictions tend to struggle with it. I wonder if you could just sort of talk us through the policyholder relationship with the insured, and whether the policyholder can actually be the insured as well.
Yeah, so the insurable interest, first of all, I think if we're familiar with Singapore and Hong Kong, then we're in jurisdictions that have the concept of insurable interest, and the idea is that I can't go and insure somebody's life if I may stand to benefit from them actually dying. I need to be in a position where I suffer some loss if somebody's going to die. Otherwise, I could insure the life of people I don't like and then take steps to see that I redeem the insurance proceeds. So insurable interest is the sort of the public policy point where different jurisdictions define who has insurable interest. So Typically, it's a spouse and minor children. In Singapore, a trustee can have insurable interest in the life of a settlor. That's not the case in Hong Kong. But it's interesting that in many jurisdictions, they don't bother about insurable interest. In Bermuda, you can insure anybody's life as long as they agree. And there are other jurisdictions which just don't have that same concept. But I think it's quite a good, it's quite a good one. And it's something, if you're setting up an insurance contract, it's one of the things you have to check, that there isn't a risk that the contract could be voidable because it lacks insurable interest. So typically the policyholder will insure very often their own life with the family as beneficiaries, but they could insure the life of somebody else subject to insurable interest if they're in a jurisdiction where that's important.
And how many sort of insured can we have? Because we can have joint lives, I suppose, but can we just keep going a bit like from a trust perspective, having like a sort of a kind of
no, you can have multiple lives assured. In fact, I might sort of call on Yannick here to maybe speak about Europe. I think you've probably seen multiple lives insured there, Yannick, haven't you?
Happy, to say something. Definitely, a lot of insurance carriers allow actually to have several life assured. Sometimes vary up to 6, maybe sometimes even 8. I think what is here maybe crucial, and we're coming to the text part later with Michael, but certain insurance companies, they also allow to change insured persons and think, okay, then you get this basically longevity of the insurance policy, as Zach, you have mentioned. But the issue here is very often this is an innovation of a contract and typically triggers taxes, at least in developed jurisdiction in Europe, for example. If you change an insured person, obviously that's the heart of the insurance policy, then you would actually trigger taxation by novating the contract.
Is it possible to insure a minor child, like a sort of newly born child? Is that possible, so that we can get the maximization?
Absolutely. Typically, a lot of insurance jurisdiction, they allow to have minors insured, and therefore you can basically have your kids and then have basically a contract running for a very, very long time.
Right. So effectively, insured is akin to the trust period in a sort of broad sense of the word. Okay, looking at the beneficiaries, when we look at the PPLI policies, does this tend to typically obviously be individuals, or can we have companies and sort of legal arrangements, or how does it typically configure, and are there any restrictions on the beneficiaries that we can actually have involved in policies?
I think you see all of those situations. Companies, can take life insurance on. You've probably heard the expression key man insurance. So companies can insure a very important executive, and the company could be the beneficiary of the policy to protect against the problems that will arise if that key person disappears. So that certainly happens. In most cases that I've seen, Yannick may have seen very different ones, but I suppose the majority tend to be individuals. But I think increasingly, and maybe it's something that we'll talk about later in this session, having a trustee as the beneficiary of a PPLI contract can bring together the advantages of both the PPLI and trust. But perhaps we'll get to that a bit later on.
All right. Now, another bit that we were talking about was this thing about life cover. And within the PPLI context, we have a life element, and we also have a cash value element. And what I would like sort of Peter or even Yannick to discuss is the relationship between these two. So if we go back to the life cover, is there any mandatory life coverage percentage that we need to be concerned of? I know you mentioned earlier, Peter, about the sort of 1% type policies, but and obviously I appreciate that some of these policies will point into different jurisdictions that may have different rules, but as a matter of course, what are we talking about here in terms of life cover? Does it need to be a nominal amount, or does it actually need to be substantive? What's the thinking?
Well, there has to be some, right? There has to be some, otherwise it's not an insurance contract. But in many jurisdictions, if you look at the legislation, it can be nominal, and in many jurisdictions, 1% is fine, or even a fixed sum, which could be less than that. However, and it can be greater. So you know, as I mentioned, I think, you know, a lot of people feel that PPLI is something with the 1% life cover. Actually, you could have 100% life cover. If you've got $50 million of assets, you could get some very high life cover, subject to all the normal conditions of health and so on. So you can have very high life cover in the PPLI policy, because if you put things like your family business and your real estate, commercial property, and your land and everything underneath, it all counts as premium. You can end up with a premium that has hundreds of millions of dollars. Right. And on top of that, you can add substantial life cover. But I think the interesting point of whether 1% is enough, I think, I don't want to jump the gun too much. We're going to have a section a bit later on tax. The issue, I think, is that there are many jurisdictions, and you can take maybe Australia as an example, where legally it's enough to have 1% life cover. But you really have to think, if you're an advisor, whether you want to recommend that to a client, because many jurisdictions now are looking at general anti-avoidance rules, where, you know, the insurance industry might be fine to say, yes, that's an insurance contract, but the tax office may have a different view and may say, look, wait a minute, don't tell me you did this for life insurance reasons. It looks to me like you've done this entirely for tax avoidance. And I think this is a real risk now, as we see the tax world evolving very fast since CRS came in. A number of jurisdictions are looking again at their tax regulations. And I think I'll defer to Michael later, who's going to talk more about this. But I think whether 1% is really enough these days, I think you really have to think very hard.
Right. And in terms of the cash value, just simplistically, is that there effectively to fund the life cover, or is that where the life cover comes from? Or on a PPLI, are you just doing a single premium, or can you spread it out and actually use the cash value to fund it? How does it actually interrelate?
Well, there has to be some liquidity in the policy, because annual cost of insurance has to be paid. So typically the carriers will look at, when they're looking at whether they will accept assets, you know, a couple of things that they will look at is, you know, one, can we get good valuations? You know, can we value all the stuff that's coming in? And secondly, is there going to be sufficient liquidity over time to pay the cost of insurance, depending on the level of the life cover that's being requested? So, you know, commercial property that is generating rental income, for example, would be a good asset to have. But if you have something that's purely, you know, that doesn't have any income at all, then that's something that would be a consideration for the carrier. The other thing which is relevant here is, for CRS purposes, it's surrender value that gets reported. So I'm not sure if that was part of your question, Zach.
No, we'll get some of that CRS analysis a bit later on. Okay, so I think in terms of just looking at the two side by side, obviously, you know, one is contract based and one is a sort of fiduciary based or obligation based. I think the main sort of takeaway, and I think we can all join in on this or chime in, well, the main takeaway is within the trust context, there seems to be a lot more wiring in terms of governance and balancing different powers, etc. Whereas within the policy context, it looks like the policyholder is the main sort of person in that context, as against the trust, where it seems to be a whole sort of dichotomy of different power holders. Obviously, within the policy, it's also got a very much an investment side to it as well. Whereas within the trust context, it can be, in many cases, just a sort of static holding vehicle, and that's sort of expressed by it not needing to maintain life cover and all the rest. So it seems that the two, just at the beginning of this, we can see some of the reality of, they're both asset holding vehicles, but obviously a policy is a contractual based approach, whereas a trust is a fiduciary based approach. And so this will be borne out during the course of our discussion, that some of these differences will come to bear and some of the advantages, disadvantages will be sort of highlighted. But at the beginning, it just looks like the trust, there's a lot more wiring that we can done, a lot more fine tuning. The perpetuity period of a trust in Singapore is 100 years, and in other jurisdictions it's in perpetuity, so it doesn't end. Whereas with a policy, you do have an end stock, because you have the insured that will bring this to a halt if they are no longer sort of around. So I think those are the sort of high level sort of discussion points as we roll in to discuss them in more detail. So going on to the life cycle comparison. So here we're looking quite simplistically at the creation of these various structures and seeing the differences between the two. So from a trust creation's perspective, you're looking at the assets being put into the trust and the settlor. And very simplistically, what's the process and procedure to establish a trust? Settlement of company shares if you're doing that, and the time to create. So Marcus, from your perspective, just very, very sort of briefly on this, what's actually involved in onboarding, and not necessarily looking at AML and all the rest, but just looking at the mechanical side of onboarding a new trust and the procedures that are gone through to actually begin the process of settling the shares and bringing the trust into life, and the main component parts that you need from a trust to make it valid.
Yeah, okay. So setting aside the AML, the regulation side of it, actually setting up a trust on its face should be very straightforward. What we're talking about is the beneficial owner of an asset, someone who absolutely owns it, is making a gift to a trustee to hold that particular piece of property on trust. In practice, it gets a little more complex than that. The obvious complexity is what are the terms of that trust? So it can be an oral trust. Now I can give something to Zach and just tell him what the terms are, but obviously that's not going to work in our industry. So we need to have a trust deed. So immediately you've got a degree of complexity because that trust deed can come from a precedent, but it's often something which is pretty bespoke. Once we have the trust deed prepared, and that will take a little bit of time, then we need to obviously ensure that the settlor validly owns the asset that he's transferring over, and that he needs to own it himself. And then we have to have, obviously, there's tax considerations and other issues involved in the actual transfer of that asset that need to be considered as well. So although on the face of it, it might seem quite straightforward, there's actually quite a few hurdles to get over in terms of that procedure to establish the trust.
Right. Now, looking at the PPLI creation, same questions. Process and procedure to establish a PPLI, subscription in kind. So here we're not putting cash, we're actually, as said earlier, we're using shares as the basis on which to subscribe. And then the estimated time to establish a policy. And I think, Peter, I'd invite you to run us through this, and particularly, unlike a trust, I suspect on the PPLI, there may well be some medical sort of tests that need to be gone through, because there's likely to be life coverage on this. But if you can talk us through from a PPLI perspective, how intrusive is that, or do we actually have to have that at all? And the process, of course, to subscribe in kind using shares.
Sure. Well, whether there's a medical test required depends on the extent of the life cover. And if we're looking at something very nominal, then that usually is not an issue. If there's substantial life cover, then there will be a health test required. And that's, of course, made more complicated now with COVID, because it's more difficult for clients to travel to places where carriers are comfortable that the medical facilities are reliable. Although a number of carriers have come up now with solutions where if the life cover is less than $2 million, for example, they will make exceptions. So leaving aside the health cover, the transfer to the insurance company is very analogous to the transfer to the trust company, in that it could be a chargeable transfer for capital gains tax in the client's home jurisdiction. So it could be a tax event, which we'll come to later with Michael. How long it takes? I mean, the process is pretty straightforward. If you're dealing with BVI company shares, you sign the contract with the insurance company, and you transfer the shares into the name of the insurance company. So that's pretty straightforward and doesn't take very long at all. What can take time is if you can't use an underlying company, because there are a number of jurisdictions where if you want to achieve a tax result in a country like France or the UK or the US, There are a number of jurisdictions where to have a tax compliant policy, you need to have the financial assets themselves held in the name of the insurance company. And the problem that comes there is that the insurance company has to open an account with the private bank of choice. And then the delay is usually with the account opening with the bank. They may not be used to opening an account with an insurance company. They may think that they can't do it, and they may not understand why they're doing it. And I've seen cases where it's taken almost a year by the time KYC and compliance and legal and credit and everybody gets involved. And finally, they get what's going on, and it can be done. But that's where the delay can come. If you're just transferring the shares of a BVI company, it can be very straightforward. And the underlying bank accounts, if they're already held in the name of the BVI company, they don't have to change. They don't move. At the bank level, there will be another level of KYC has to be done on the insurance company now, but that's usually not a big problem. But the process itself is very straightforward.
And how many of the PPLI policies are reinsured? So how many times do you actually get the reinsurer, the life company that's reinsuring, actually take an interest in this process?
I'm not sure I understand the question, Zach.
It's sort of let's say the initial carrier is reinsuring the risk of this policy. The company that they're approaching, the other life company that they're approaching to reinsure the risk.
Oh, right. Well, okay, so that would happen. I'm going to defer to Yannick, but that would happen if there's significant life cover, right? So let me bring in Yannick here for his experience on this.
Absolutely. I think it depends very much on the risk that you insure. Typically, the fronting insurance companies, they have a certain cap where they're willing to take over the risk. With certain PPLI carrier, to be honest, that's super low. So already when it goes into the couple 100,000 of death benefit, which you obviously can easily achieve when you have, even if you have a 101 on a couple million premium, then the reinsurance company comes into place. And there it obviously then depends regarding medical, how much risk is insured. Do they just have a questionnaire? Do they need to be sent to the medical check? Some carriers go to 500,000 without medical check, some 2 million and slightly above. So it depends very much in the market.
Right. Okay, so I think broadly the process to create is fairly similar. I think that the sort of AML nightmare is probably similar as well in terms of shifting it over from individual ownership into, in the case of a trust, the trustee, and in the case of the PPLI to the life company. Depending on the life coverage, you may encounter delays when it comes to medical testing. Obviously, in the current environment with COVID, that can also be exacerbated, but it's all sort of horses for courses in terms of the amount of delay that you might be encountering. But the general takeaway here is that it's pretty similar in terms of the setup and the process to constitute the trust and the policy itself if you're using shares.
Yep.
Right, from an administration standpoint, so this is where you have the policy, it's up and running now, the trust is up and running, and these are the main sort of administrative points that we're going to sort of look at. So control, how do we actually exert or reserve control? How do we extract benefits from the particular structure? What are the asset protection attributes? And then finally, the taxation, how is it dealt with? So from a control standpoint, obviously from a trust, it's going to be the relationship between settlor protectors and the underlying company. The methods to control a trust, and I'll just run through and canter them. Complex PTC structures is an example. Settlor reserve powers, those are very popular in Singapore. Powers to appoint and remove directors, these can be directive powers. Powers to direct investment policy. And then the rather odd way in which trusts seek to exclude trustees from involvement in underlying companies by what's called the Bartlett clause. So sort of Marcus, from your perspective, when we're looking at how trusts are, how we have this mix of control, generally, how does it configure in the marketplace? Do we end up with quite high amounts of trustee discretion without any level of reserve power, or do we always have a reserve position where there's a mix of powers being used? And if we do, is it predominantly reserve powers, or is it the use of a private trust company as a way of doing that? And in the mix of all of this, how do we end up with a Bartlett clause for members that are watching this that are not aware of what a Bartlett clause is seeking to achieve? So just broadly, if you can run through.
Certainly from a trust perspective, the takeaway here is there's a lot of flexibility. So there's a number of ways to slice this particular control issue. You've mentioned them there. The most common by far in Asia, but I would stress in Asia, is the set law reserve powers. If I went to a jurisdiction such as Guernsey, for example, or Jersey, you will see much lower uses of reserve powers.
Right.
You know, in Asia, set law reserve powers is by far and away the most common way of clients of set laws exercising their control. It's a very direct way to do it, and it's a very effective way to do it in relation to investments. But also, clients will often want control in other areas as well. And because of the flexibility that you've got, the reason for that flexibility is because what we're talking about with trust is a relationship between set law and trustees. So that relationship can be defined in the trust document. So you can identify and bespoke what kind of control you want. You can also, as you mentioned there as well, the power to appoint and remove directors at the underlying company level. So you can also tailor your constitutional documents at the corporate level as well to ensure control is where it needs to be. And of course, you've got the age-old issue of if you have too much control, is that going to be a problem from an asset protection point of view or a tax point of view? So a good advisor is going to be discussing the downsides of having too much control. But I think take away from a trust perspective, you've got a lot of flexibility built in to be able to carve out what you want.
Well, then we also get this rather odd thing of having what's called a Bartlett clause in the mix, and that seems to sort of try to cut off responsibility at the trustee level for any of the sort of activities of the underlying directors of the underlying companies. Is that your understanding of how Bartlett clauses are tending to be used? And
yes.
Sorry, aren't they? So,
for those of you who are familiar with trusts, then you'll be aware that case of Bartlett versus Bartlett Bank provided that the trustee has this high-level supervisory responsibility over the assets of that trust. So one of those incidents of that is that the trustee needs to know what's going on in its underlying companies, which of course, from a client and trustee perspective in the modern world, that's not particularly advantageous. So great in the old school kind of trusts, but where you've got a set law that's still alive, wanting to say put a family business into the trust and wanting to really control what's going on, the trustee having this high level of supervisory responsibility was something that was a problem. And so what you found is that the anti-Bartlett clause came up and started getting drafted into trust deeds, which basically said the trustees do not need to, unless they have actual notice of some fraud or wrongdoing, they don't have to look at what's going on in the underlying company. The problem is that the courts have been a bit inconsistent in how far they're willing to allow the trustee back off. And so as a consequence of that, you did see jurisdictions such as the BVI come in with specific trusts, in that case the Vista Trust, which was all about the trustee not having a responsibility to look at underlying companies. But this problem of how far does the supervisory responsibility go is a real today issue for trustees.
yeah, right. Okay, so I think the mix here is that, as with all things trust, it can be quite flexible. You can create the trust where the trustee has minimal interference, where a lot of reserve powers are put in, or you can put it in such a way that the trustee is disconnected from the underlying company, and the directors of the underlying entity can have more of a say in the practical side. So it just shows that the amount of work that's been done over the decades of use of trusts in the modern context allows you a fair play intermixing provisions to allow a tailor-made solution for clients and their governance mechanism, the way that they wish the trust to be modeled. From a PPLI perspective, looking at it, going through this control aspect, because it is so critical, the question being asked is methods to control the underlying company and its investments, and also things like appointment removal and remuneration of the directors of the underlying company, and the investment policy guidelines that they'll be following going forward, given that in this case, the policyholder has given up or divested themselves of the shares in the company. But obviously the control aspects will be quite critical. So I'd invite Peter to just sort of canter through, how is this dealt with in a PPLI policy? How is this control aspect, which is so obsessive in the marketplace, how do we deal with it in the PPLI context?
Yeah, well, one of the nice things about the insurance, using insurance with planning, is that you don't have the problem that trustees have, which is the whole fiduciary responsibility. And although, you know, you make the point very well that you know, things like the Bartlett language and so on have minimized some of the difficulties for trustees. You know, we've still seen court cases just in the last 2 or 3 years on the subject of Bartlett and whether trustees don't have an overriding responsibility. So the trust waters are sort of slightly muddied with this fiduciary duty, and the beauty of the sort of contractual approach is that it's very clear who's got what responsibility, and the policyholder has most of it, right? And has tremendous power just to sort of call the shots. So I think it's a very interesting point about removal and remuneration of directors, because although the policyholder has pretty much all the rights over the policy, including cancelling the thing, for the day-to-day operations, you do have a situation where the shareholder of the company is actually the insurance carrier. Yeah. So in theory, the shareholder would have the power and authority to remove directors and so on. Although in practice they don't, because they're not really interested in getting involved at that level. So how that is documented, I think, you know, perhaps Yannick might want to comment, but I don't think it's documented. I think it's more by agreement that the insurance company is just hands off on that area. But Yannick, perhaps your thoughts?
Yeah, I think there are different ways basically to do that. First of all, the client can basically tell the insurance company to waive the voting rights back. And obviously, if the client has the voting rights or his lawyers, etc., that gives back a lot of control. Additionally, what we see more and more, there is actually a kind of director agreements or mandates basically implemented from insurance companies, which give certain rights, etc., which needs to be signed off by the client, and therefore, obviously, it gives back a lot of control to the client, that he can say, okay, these are now the directors which should be assigned, and these are their rights and obligations, etc. And so they're more and more involved in I would say, a day-to-day basis as well.
I mean, you know, one of the aspects on trusts, and if we use it from a sort of Southeast Asia perspective, one of the uses is going to be obviously family business succession planning. And inevitably within that context, there'll be quite complex governance rules that are being agreed between the family members as to how control is to be exerted, who can participate, how can they benefit from these things, and looking very carefully at people abusing their positions. These are the general sort of governance compass issues that usually come up. And what I'm understanding is that if I try to recreate a family business within a PPLI, outside of a trust, but just into a PPLI, that in effect, I would need to have collateral arrangements put in place with the life company in order to affect that sort of sophisticated multi-generational governance. Is that correct?
Absolutely. I think in the end, I see it very similar like with the trust, because obviously you have the trustee holding the assets. Here you have the insurance company, so you need to implement the same mechanisms. Though what I have to mention here as well, obviously it depends, it's very jurisdictional driven, if you can even hold really operating companies to that extent, because there are certain jurisdictions which don't allow that, specifically for PPLI. Certain others, they are more flexible. But otherwise, I would say the mechanism you can really build in similar like with a trust.
Is it right to say that the same admonition that we had at the beginning when Peter was outlining the PPLI policy is be careful how much you reserve out back to the client, in the same way as be careful of how much you squeeze the life cover to be at, let's say, 1% in the sort of post-COVID environment where potentially tax administrators are looking carefully at whether or not these are bona fide structures. That's something that you worry about, where clients want to exert the same level of control that they want to on a trust, but they try and test whether or not a PPLI can also perform in the same way.
Absolutely. I think that's actually crucial with PPLI, because that's exactly what we have seen in the past in the US happening in the 90s. We have seen it in the early 2000s, where people have kind of set up these insurance wrappers, which I don't like. PPLI is not an insurance wrapper. An insurance wrapper usually stands for non-compliant products, in my opinion, where they basically just went somewhere, Bermuda, Liechtenstein, or Luxembourg, or wherever, bought a product and didn't think about the actual regulation in their home country. Obviously, this has now changed a lot. Now you really, even if you have an Indonesian client, you need to set up the policy according to the Indonesian rules and think about what is compliant there. And that's why it's so crucial to have guys like Michael are also in the boat, who exactly know how it needs to be structured, what needs to be fulfilled. So it is an open architecture. You're very flexible. You can do everything, but you need to really stick to the rules to make it compliant.
Okay. We just sort of high level comparison between the two in terms of looking at control. Trusts, it's a well-trodden path. I think PPLI is fair to say that it's an emerging area. There's some level of restriction. You have to be careful that you don't inadvertently invalidate the policy, or at least put it into some level of distress if you're pointing into a jurisdiction that doesn't want you to do that. But it's possible to do it through contractual arrangements or collateral contractual arrangements. Within the trust, it's a little bit more straightforward, and the mixing is a little bit more straightforward. But it's not to say that you can't do it. So it is what it is in terms of sort of using the contract as a sort of holding vehicle. You just need to be careful. Within the trust, it's probably more sort of typical and more widely trodden.
Zach, I think one point that's worth making just on that control point is that some of the limitations for control with a trust are around, the validity of the thing, right? Whereas the sort of the limitations, if you like, around the policy, really to refer back to Yannick's point, that the limitations really come from the result you're trying to achieve in the jurisdiction that is relevant. So if you're trying to achieve a legitimate tax result in the US, or a legitimate tax result in Europe or Japan or anywhere, that's going to be the thing that gives you the limitation on what you can and cannot do typically. So it's a little different from the limitations that you have in the trust area, which tend to come from more the
I completely agree. If you go over the top with the trust, you'll end up with a nomineeship, nothing more, or you'll end up everything being held effectively for the power holder. So it's true. And the jurisdictions have struggled with the mix of powers that you can reserve within the trust and still have it as a bona fide trust going forward. So you're absolutely correct. Okay, benefit. Now, this is fairly simple. In terms of trusts, you can have reserve powers that can allow that distributions are made at the direction of a settlor or a power holder. You can use trustee discretions. It's with respect to the class of beneficiaries, which can be extremely wide in terms of distributions. And distributions can be either straight up cash distributions or appointments, and the appointments can be a cash, loan, shares, or indeed there can be absolute contingent, or you can create subtrusts. So within the trust context, is it right that we have such a broad optionality as it respects benefits that can be conferred across to beneficiaries? But Marcus, from your perspective, when we're looking at distributions from trust, is it really that much sophistication, or is it really just looking at cash distributions in practice? Or do we get into very complex sort of re-engineering through contingent interests and subtrusts? What tends to be the case in the market?
Well, I mean, most of it is cash. to be fair. But certainly there are occasions where you'll see loans and in specie distributions and that kind of thing, and that is driven by all sorts of different reasons, including tax. But generally speaking, it's cash distributions.
And it tends to be a class of beneficiaries rather than life interest or life tenants or income interests. It tends to be broad classes of beneficiaries. It seems to be the norm.
Yes, that's a fair point.
And it also tends to be settlor interested trusts. So we don't have the sort of settlor exclusions that we would expect from sort of high tax jurisdictions. Is that also?
Naturally, being in Singapore, Hong Kong, we have the luxury of a pretty simple tax regime when it comes to trusts. So we don't need to get too complex when it comes to that.
Okay. Now, from a PPLI perspective, if we're looking at policyholder distributions, policy surrender, beneficiary distributions, and then the distribution type, cash, loan, or shares. I think the general sort of point here, I think we'll ask Peter to kick off as usual. A policyholder distribution, is that a surrender effectively of the cash value or the premium, or what is actually going on there when you have a policyholder distribution?
Yeah, it'll be typically a partial surrender of the policy or a total surrender of the policy could be to the beneficiaries, or the policyholder actually has the right to cancel the whole thing and take the funds back. Where there may be a restriction could be if there has been an irrevocable nomination of beneficiaries, which the policyholder may have done in order to, for tax reasons or to protect himself against creditors. In some jurisdictions, it may be necessary to make an irrevocable nomination of beneficiaries, in which case the policyholder would still have the right to instruct a partial or total redemption, but then the benefit would go to the nominated beneficiaries. But it's essentially pretty straightforward, and the distribution could be in cash or it could be in specie. And in fact, we have been developing some solutions where insurance carriers can hold onshore assets of clients in certain countries, and then with the ownership of those assets, those onshore assets, they add significant life cover in the offshore world, and then after the lifetime of the life assured, the cash life benefits fall into an offshore trust for the next generation, whereas the onshore assets are then distributed in specie. So there's a lot of kind of little tailored solutions that one can do in this area, but it's you can do both. All of the above is the answer there.
Okay, so I think from just a sort of distribution standpoint, looking at there seems to be quite a similarity between the two. Doesn't seem to be much different. Obviously, the surrender aspect is the mechanics of it, but you achieve the same result. So I think in terms of any big difference, there doesn't appear to be any that's revealed by this. I suppose the issue is that with the trust, obviously, you can have a greater level of resettlement, as it were. So there's some sophistication on the distribution, whereas with a PPLI, you wouldn't necessarily be able to do that level of sophistication on the post-distribution structuring. But otherwise, it seems to be quite similar. Asset protection. So looking at this from a context of the settlor divorce community property. So divorce as a settlor, looking at nuptial settlement variations, divorce powers to claw back assets in trust, and community property rights, assets in trust. Again, very quickly, Marcus, on these are the frontline risks that we encounter with trusts. And nuptial settlements is something that comes out of UK Matrimonial Causes Act. It's not been widely adopted in Asia, the concept of a nuptial settlement. So the divorce courts have generally not had to trouble themselves with that in Asia. But the divorce court powers to claw back assets that you've put into trust in contemplation of divorce, and the community property rights to assets in trust, those are live risks, particularly community property if you have Indonesians or, let's say, Filipino couples. What's the general sort of consensus here in terms of the risks of trusts being attacked by these sorts of devices where you have a marriage breakdown?
Yeah, I mean, very much jurisdiction specific now when we consider the value of trusts when it comes to divorce. So, you know, it's widely known how, you know, how aggressive the family court is in England, for example, about clawing back or varying trusts to affect both parties. In Singapore as well, you do have the right under the Women's Charter to claw back assets under a trust. Generally speaking, though, if you've settled a trust with your own assets before marriage, those assets are protected against later divorce. The issue of community property is obviously extremely important, and it's the wider issue. I think before this, Peter made a very good point about trustees need to be concerned about the fact that when a set law purports to transfer assets to a trust, and I mentioned earlier that need to ensure that those assets are his, that particularly is important in the divorce context, because if it turns out that that was matrimonial property being transferred into a trust by one of the parties, then you may find that later that property is subject to clawback as well. So certainly, I mean, trusts are a valid asset protection device for divorce planning as well, but you've got to be very careful about how you do that, making sure you're not putting in matrimonial property at the time, and then making sure that you haven't done the trust in sort of contemplation of marriage or anything like that.
Yeah, and generally community property, the firewall protections around trusts, even in sort of advanced international financial centers, generally they'll protect against community property because it's property you never had in the first place. So they don't generally protect that. From a PPLI perspective, if we run the same scenario, presumably divorce courts have power to effectively get hold of or assign the policy as they wish as part of the divorce settlement. But crucially, on the community property aspects, if the life company or let's say the broker is aware that the property being put into the PPLI is actually matrimonial property and there is a community regime, is there a risk that the policy holding these assets, that they can be attacked on a community property rights claim? What do we see in that?
Yes, but I'm going to let Yannick answer this because he comes from the community property world, coming from the civil law jurisdictions of Europe.
Thanks, Peter. Yeah, you know, obviously that is kind of a topic, and it's a very, very tricky question with community property. And I have the impression that's a topic which is not widely enough discussed in the PPLI space. There are certain jurisdictions which it's more relevant, but it's obviously super tricky. I can explain you one case. Obviously, for the preparation of this seminar, I have actually really discussed with a couple of partners, and there is obviously very different aspects coming in. And a very interesting case that we actually had of one of our partners is in Germany, where there was also community property. The transfer into the policy came from a joint account, husband and wife. And then the husband set up the policy under himself, policy or the insured person. They did this decision together to do that. The interesting aspect here is obviously you could think, okay, it's still community property, etc. Though the tax authority actually then came in from a very different angle and said, this was a gift from the husband to the wife, and you have a free allowance in Germany of 500,000 euro. Everything above is taxed. So I would say there are lots of traps around. I think in the end, still the asset protection, how it's set up with the PPLI, and we go more into detail later, is if you protect your family for the policy, then typically the courts where the insurance company is based sticks to that. And we have even seen work that actually working out with divorce cases where the beneficiaries were protected, and then the court where the insurance company was based protected kind of the right of the children to be protected versus the right of the wife to get actually half of the policy.
Right. So it's still effectively a bit of an emerging area.
Absolutely.
Not enough going on. Yeah. Okay, now looking at settlor bankruptcy, here the usual risks are that we have a clawback right. So settlors creating trusts just to effectively avoid their creditors. As I understand it, in Singapore, we've got effectively a 5-year sort of period during which these can be at risk. Other jurisdictions have much shorter periods when it comes to trusts. 2 years would be typical. Marcus, from your perspective, asset protection trusts and creditor clawback rights, it's not, it's certainly from a Singapore perspective, Hong Kong perspective, these are not asset protection jurisdictions. Is that right?
Yes. No, that's exactly right. The those jurisdictions that claim to be asset protection jurisdictions tend to have, as you mentioned, very short periods of time, 2 years or such. They also make all sorts of roadblocks for the creditor. So if a client is specifically looking around for asset protection, probably Singapore and Hong Kong aren't the best places to choose.
From a PPLI perspective, so we're looking at the sort of creditor protections for creating a PPLI. Obviously, this is all topical because, you know, with COVID, there are going to be obviously high net worths that are going to be in trouble. Okay, they may not be high net worth anymore, and they'll be looking at some ways in which they can protect their assets from the potential of creditors coming against them. That's not to say that they wouldn't look at trusts or any other sort of platforms to do that. But from a PPLI perspective, is there an inbuilt creditor protection within that, or is it sort of open architecture in terms of the rights of creditors to come against the policy?
It's very, very jurisdictional specific, Zach. And it's very important when you know, when clients are looking to buy insurance, it's very important that they get the right advice on this kind of thing, as well as, of course, tax. So, you know, the approach of just going and buying a product that a carrier has, you know, can go wrong when it gets stress tested with things like, you know, the community property and the bankruptcy and so on. Bankruptcy in particular varies a lot by jurisdiction. There are some jurisdictions where to protect your assets, then you have to, as I mentioned slightly earlier, make an irrevocable nomination of beneficiaries, usually to family members. But I know that Yannick is aware of other jurisdictions where you have much greater protection. So again, I'll invite Yannick to comment perhaps.
Yannick?
Yeah, obviously it's very jurisdictional driven here. It's the asset protection laws in the PPLI space, they are very, very differently drafted, I would say, where you have, what is obviously very crucial is how long does the PPLI need to be in place to really get the full protection, where in general you can say Europe is 12 months. On the other side, there are certain jurisdictions in the Caribbean, they have maybe stronger protection already after 3 months in place. But the crucial thing is obviously always that you haven't just set it up to kind of put away the assets, or you knew already that you're going bankrupt or the litigation is coming up, or it's stolen money or whatever, then obviously it doesn't help. But it can be a super great asset protection tool if you do it for the right reason and if you set it up at the right moment.
So the fraudulent conveyance considerations would still generally apply.
Absolutely.
Okay, just going through quickly on trustee liquidation and trust fund. I think I can deal with this very quickly. Trustee liquidation won't have an impact on the trust fund. The only thing that will happen is any trustee rights subrogation will then be normally respected. So anything that's owed to the trustee can then be extracted. But otherwise, the trustee going bankrupt or liquidating, in this case, would be neither here nor there from a trust perspective. From a life company perspective, a life company going into liquidation, of course, everyone's worried that, you know, with COVID and with the claims and all the rest, maybe some life companies may not survive. I don't know whether that's a right sort of assertion or not. What is the situation with respect to my PPLI policy and my company shares? Are they going to be absorbed with general creditors of the life company, or how does it work within the PPLI perspective if the life company goes under?
Okay. As a generalization, it's very analogous to the trust. So PPLI assets would be protected in virtually all insurance jurisdictions. The only thing that may vary a little bit would be where there has been life cover added. You know, would the what would happen with the underlying portfolio is that another carrier would be instructed to take over the policy. Where there was a life cover commitment, there may be some negotiation in some jurisdictions of whether exactly the same terms and conditions would apply. But very jurisdictional specific, I think. Generally speaking, everything's protected.
Yeah, on the liability side, I think generally we've basically seen the same thing coming out. I think the PPLI is seen as a little bit more asset protection geared. Obviously, some trust jurisdictions allow it, but we can have as low as 3 months. Obviously, fraudulent conveyance would override that. But in terms of the asset protection itself, you can probably be a bit more aggressive on a PPLI than with a trust. Community property, generally the same problem with trusts as it is with PPLI, so an emerging area. And that's not to be sort of surprised. On divorce court wise, again, clawback is within the trust domain, and use of the policy or surrendering the policy or assigning it is well within the remit of a divorce court, so no change there. Okay, taxation. Okay, preliminary issues on the validity of a policy. I think before we even talk about the tax treatment of the policy itself, we need to get happy that the policy will be respected by a relevant tax administration. And here, obviously, Michael's going to be talking a great deal on this going forward. We're going to be relying quite heavily on looking at how things are developing in Indonesia when we discuss some of these things. But before that, I'll just kick off by sort of running through, in terms of the life cover element, if we're looking at it from, let's say, an Indonesian perspective, where are we? Are we more than 1%, more than 15%, more than 20%? Michael, what is the life cover for a policy that's looking into the Indonesia market?
Yeah, thanks, Zach. Maybe just to make a couple of general comments first, and you know, first is obviously I echo Peter's comments from earlier. When it comes to taxation, it is going to be very jurisdiction specific, and you know, when we look across the region, you just got such a vast sort of spectrum of tax systems, you know, from less developed, you know, to very sophisticated, very mature, you know, and Peter talked about Australia at that end. So you've got, you know, different levels of detail and regulation, guidance, case law, etc. And then each, you know, you can see different approaches to anti-avoidance, you know, very formal general anti-avoidance rules, GARs, such as in Australia, or even in sort of India now, you know, to more, you know, general substance over form type principles, which, you know, are a little bit less kind of prescriptive in terms of when they would apply. So you've kind of got that spectrum, and this is going to sort of, you know, be a theme throughout the whole sort of tax discussion, that, you know, issues such as validity, or, you know, whether there's a, you know, how you look at a tax event, etc. It's all going to sort of be very specific to the jurisdiction. But to take, you know, Indonesia as an example, you know, there is no specific tax regulation or guidance on this question. I think the view, you know, to date in the market is that, you know, 1% would be acceptable. But as I said, you know, that is in the absence of, you know, specific provision, specific guidance, you know, to date. And I think, you know, the other thing when you think about a jurisdiction like Indonesia, which I think, Zach, it's, you know, why it's such an interesting one to sort of call out, to sort of apply, you know, the sort of some of these issues, or test some of these issues, is that, you know, it was really only during the tax amnesty that the tax authorities started to develop an understanding of things like trusts and insurance. You know, there was a sort of, I think, you know, some sort of expectation at the time that might lead to more specific guidance, more specific law and regulation around this, but we haven't necessarily seen that. So it still is, you know, sort of, you know, fairly, you know, sort of looked at in the absence of very specific, you know, details. You know, the other thing in an Indonesian context, I mean, whilst there's no sort of specific GAR, there is a substance over form principle. How that would apply in this context, I think to date it hasn't been sort of viewed as disturbing the categorization. But I think to Peter's point earlier, as authorities become sort of more sophisticated, as for instance through CRS exchange, etc. Perhaps there'll be sort of a finer analysis around some of these points. But at the moment, I think the broader market view is 1% would be acceptable.
Right. And in terms of the actual cash value itself, do we have a mandatory cash value amount or restricted policyholder control? Do we have any sophistication around how to deal with the sort of investment side of the policy when it comes from an Indonesian standpoint, just to give us an example?
Yeah, certainly not as we would see it today, no.
Right. All right, so looking at just the creation. Right, Michael, is that all right?
No, yep, no.
Okay. So looking at trust creation, taxation, tax implication, creating, transferring assets into trust, and CRS reporting. Just looking at it from the context of, let's say, an Indonesian settlor creating a trust, how is that treated? Is that transparent, or is that seen as an event, a chargeable event?
Yeah, I mean, on the face of it, when you've got a disposal, your first expectation would be that's a tax event, and if tax can arise, capital gains tax or otherwise, you would sort of think about that issue. But in an Indonesian context, you've got this threshold question: is how do you view the trust? And again, this kind of highlights the point earlier about the amnesty, and in the context of the amnesty law and the subsequent regulation and Q&As, the tax authorities sort of felt that trust should be seen as a look-through or transparent. So putting it another way, the settlor will still be seen to be the tax owner of the assets that are transferred into trust, and the income and gains that sort of flow from that and ultimately get distributed would also be sort of attached to the settlor. Interestingly, despite that, you would sort of think, well, if you got the transfer in and it's still seen, the settlor still seen to be the tax owner, you wouldn't expect a taxable event at that point. But yeah, as I understand it, there is a view that irrespective that there would be a tax on a disposal into the trust.
Right. Okay. From the CRS perspective, I think it will very much depend on whether or not the family trust is seen as an investment entity. So whether or not the settlor is seen as an account holder. If it's a passive NFE trust, then all that will happen is the settlor will then be a controlling person. So it'll be either one of the two will occur in terms of the classification and then the reporting trail that will then see. From policy perspective, so taxation implications in creating a subsequent asset for PPLI policy. Look, again, using the Indonesian example. So we have policyholders subscribing in kind. Again, how is that taxable in Indonesia?
I mean, there would be a disposal from an Indonesian tax perspective, and if there's a gain, that would be subject to tax. The interesting point again in terms of looking at Indonesia is that the premium will be satisfied via the transfer of the assets, and Indonesia distinctly from any tax event on the disposal, they view the payment of a premium by a resident to a non-resident to be subject to 10% withholding tax. If the carrier, however, is in a jurisdiction that has a tax treaty with Indonesia, such as Hong Kong or Singapore, the insurance company would be entitled to a 0% rate of withholding tax under the treaty on the basis that the premium would be business profits, to the insurance company. When it comes though to the transfer of these assets, and the example we've been working with today is shares. Obviously, you've got to look at the location of the company and whether there would be tax consequences of the transfer in that location. Issues such as stamp duty at the most basic, or securities transaction tax. To whether or not that jurisdiction could also assert some sort of jurisdiction to tax the gain, from an income tax perspective. So you've really got to look at sort of both sets of considerations when you're looking to, to transfer assets in specie and also to transfer the assets. And the same would have been true in terms of, or is true in terms of, transfers into the trust, depending on where that company is located, where the shares are located.
Right. Okay. And in terms of from the CRS perspective, the policyholder or the cash value policy will be an account holder. So it will be the annual value will be taken, as well as any distributions that are made during the relevant calendar year. So attributed income and gains from a trust perspective. So this is looking at effectively a CFC analysis. So we're looking at attribution of income and gains to the settlor and beneficiaries where there's not been an actual distribution to them. So an attribution instead. How is that looking, particularly if there's, as I understand it, there's been some developments in Indonesia that may impact this?
Yeah, I think in terms of this area generally, I mean, be it Indonesia or otherwise, if the settlor is still viewed to be the tax owner, what does the law say? What does the tax law say in terms of attributing, income and gains on a current year basis? But if we take the example we've been working with today, the trust is, seen to be looked through. You're then getting to a company, from an Indonesian perspective, that company would be a controlled foreign corporation or a CFC, and the implication of that, even if it's carrying on an active business, is that the accounting profits that accrue to that entity would be attributed, in this case, to the settlor on an annual basis, and that's how that's how CFC rules work. They seek to prevent a deferral of tax by attributing profits even if they haven't been distributed. And to date, that has been 100% of the profits would be attributed, in this case, to the settlor. What's been interesting, Indonesia has just completed a tax reform process, which led to the passing of an omnibus tax law by the parliament, and that was signed into effect by the president on the 2nd of November this year. So there are some interesting changes in terms of the CFC rules. So rather than attributing 100% back in this case to the settlor, the attribution will only be 30%. And then there's a separate sort of change which says, well, to the extent that there is actually a dividend distributed back into Indonesia, to the extent that that's reinvested, that can result in that dividend being exempted from tax. I mean, Indonesia, in terms of the process of law reform, the law itself is setting out more general principles. Regulation pursuant to that law will be issued within 3 months of it being signed into law by the president. So there's some detail that we're waiting on, which we would expect by early February. But yeah, so some interesting developments in terms of Indonesia, and given that there is a look through to the company, and the company is a CFC.
I mean, does it make a difference that it's whether you have a revocable or irrevocable trust? Michael's still with us? Oh, I think he's fallen off. All right, I think what we'll do is I'll move on to other aspects of the discussion, and if we have time, we'll come back to the taxation if Michael's having difficulties. So.
I think we seem to have lost Michael. I think no is the answer to your question, Zach.
Yes.
The other thing we didn't touch on, I think, is the CRS reporting, unless you're going to do it now. But
yeah, so I think what we'll do is we'll leave the tax bit, see if we can get back to it later on. We'll move on just to effectively the termination. So that's the last part of this. So trust revocation process and procedure, we'll let Michael, if we have time, come back to that. From a CRS perspective, a termination of trust, if it's a financial institution trust or investment entity, then you'll have effectively a universal account closure occur and then a distribution to the settlor. From the revocation process, that's generally has to be embedded in the trust deed itself as a power. So that's how we would generally have that configured. From the policyholder, I'll just deal with this bit and then we can go back to the tax. So from a policyholder perspective, Michael, we'll just come back to you in a minute. We're just going to finish.
Sure, yeah.
From a policyholder perspective, policy surrender, the process and procedure to surrender the policy, I think we'll let's ask Peter there. I suppose that's just a normal paper application by the relevant policyholder to have the policy. Is that right, or is there anything more to that?
I think that's right, unless Yannick wants to add anything. No, shaking head. I think that's right.
Okay, I think Michael, you'll chime in here, and we'll see if we have time to go back on the tax implications of a policy surrender. So here we have, let's say, using the analogy of Indonesia, an individual who's surrendering the policy. What would be the tax effects of that?
Yeah, I mean, that's an interesting question, and again, sort of the omnibus tax law, is relevant to that. So, I mean, there has been an exemption in the Indonesian tax law with respect to proceeds, from life, health, etc., insurance. And the view that had been taken is that exemption would sort of cover partial or complete surrender proceeds. So when there has been a surrender of a PPLI, that had been the view had been that had been tax exempt in Indonesia. Notwithstanding that surrender value would reflect principally investment gains. The omnibus tax law has actually changed, amended that exemption so that it doesn't apply to investment gains. It doesn't apply in the context, for instance, of partial surrender or surrender. It really now is only available with respect to the payout that would occur on death. So that's kind of quite an interesting change from a PPLI perspective. I mean, the policy itself is not seen to be a CFC. So, for instance, you're not going to have that attribution we talked about before. Yeah. The technology failed me. So, it's still interesting from that perspective. But again, as I was mentioning before, we're in that period where we're still waiting for more detail in terms of how the law is going to be applied in this situation, and certainly that aspect, at a local level, different of the associations, are sort of making different representations around that. If nothing else, at a domestic level, investment-linked policies are very popular. So, so I think we have to see the detail on that. But certainly, as the way the law has been framed, if you did have a surrender, a partial surrender, for instance, that would then become a tax event from an Indonesian perspective.
From a CRS perspective, it would be an account closure. I think the interesting aspect here would be whether or not you'd have a prior distribution or a post-closure distribution, because that will make a difference on the CRS reporting. If it's viewed as a prior distribution, then that will go in as part of the report. If it's a post-closure distribution, then that won't appear on the report. So that has to be analysis per jurisdiction as to how they treat that from a CRS perspective. Okay, now just looking at the actual insurable event occurring, so death of the insured. So the distribution implications of this, presumably the policy then effectively comes to an end, and there's a payout to the beneficiaries. But the tax implications on the actual insurable event occurring, so the death of the insured, how is that shaping up? Is that tax-free, or do you have a charge?
Well, I mean, in an Indonesian context, the omnibus tax law notwithstanding, the amendments that have been made, that distribution should be exempt from tax.
Right. And it doesn't matter if the funds are repatriated to Indonesia or they're kept in Singapore or elsewhere. It makes no difference to that tax analysis. Is that right?
Yeah, correct.
Right, so from a CRS perspective, you probably have a policyholder closure, account closure at that point. For the beneficiaries, generally PPLIs or just insurance, cash value insurance contracts, generally beneficiaries can be kept off as account holders unless the sort of carrier has actual notice that they are reportable persons. At this point, however, where they are going to receive distributions, they have to be treated as account holders, and they will be subject to CRS, the full gamut of the CRS. And there it would be a rather odd one, because there'll be a sort of account opening as well as effectively a distribution and then an account closure, because the whole process will happen simultaneously from the CRS perspective. Okay, so what I propose we do is, in the combination structures, as we go through them, we'll go through so we get to the end, and then we'll see if we have enough time to then recount back to the couple of minor bits on the taxation that we didn't have a chance to do. So on combination structures, we're looking at the use of trusts and PPLI at the same time in combination with each other, and we're trying to assess which is best. So we'll look at PPLI policy assignment into a trust, and then we'll look at PPLI policy where the trust is a beneficiary. We'll compare the two and see what sort of wrinkles come out of this when we do this analysis. So policy assignment, this is basically it. We'll have a beneficiary policyholder, individual, and then they'll assign into a trust. So they'll take the policy and they'll assign it across. And then these are the considerations that will come out of this, because the trustee now holds the policy. So process and procedure for the assignment itself, the trustee obligations that then ensue as a result of that policy assignment. Should the trustee be considering surrendering, getting distributions? Should they think about reinvesting and getting out of the policy? How do they fund the policy if they need to make payments? And then the underlying investment liability that the trustee may take on if the policy proves effectively non-performing, or it doesn't actually realize any level of investment performance. So I think I'll just invite Peter to have a think through of, or help us with the assignment process and what's involved in that. And I think sort of Marcus, we can just sort of discuss what the obligations will be of the trustee after it's assigned across, and then just open it generally for discussion. So kicking off first with Peter.
Sure, and maybe if I could just take 30 seconds, I think that in the future, we are going to see a lot of combinations of trusts with PPLI as a kind of a very, very useful planning structure for the future in Asia. And I can just pick out, before I specifically answer that question, a couple of the advantages that trusts have over PPLI. They can last forever, potentially, much longer than a PPLI policy, which ends with the death of the life assured. Distribution could be staggered over generations. For asset protection, a settlor can remain potentially a beneficiary of an irrevocable discretionary trust, but retain asset protection slightly easier than perhaps with a trust. But the PPLI policy brings international recognition in civil law and common law jurisdictions, the ability to hold complex assets, removed perhaps from fiduciary oversight of the trustee. And this comes back to Zach's question now, which I'll come back to. You avoid the CFC rules and you obtain clarity of taxation. So I do think we're going to see this combination happen a lot. I think in your example, Zach, you've got the trustee being the policy holder. I think we'll probably see that less common perhaps than the trustee being the beneficiary of a policy, because that's a way of removing some of the fiduciary oversight responsibility that you referred to until after the lifetime of the life assured, when perhaps assets can just be distributed. But if you're asking specifically about the responsibility of the trustee as the policy holder, then I think we'd be looking to box it in with some equivalent of the Bartlett language in the trust document, because I think typically you'd want to obtain the same sort of non-interference situation of a trustee. You wouldn't want to suddenly encumber the trustee with all the responsibility of the underlying assets.
Yeah, I mean, typically though, are the trustees actually configured to sort of ring fence the investment in that way? I mean, is that generally what you see? Marcus, from your perspective, when you've seen these, are the trustees generally ring fence so that the policy performance is neither here nor there from the trustee's perspective, or do we end up with a situation where there's potentially some level of trustee oversight required from an investment standpoint?
Yeah, I think we would certainly want to, as trustee, you'd certainly want to be bespoking the document a bit to make it a bit more protective in relation to the trustee's obligations. I mean, it does raise very interesting points. If the trustee, so now what we've got is the scenario one is the policy is now an asset of the trust. So just like any other asset, the trustee has responsibilities of good prudent management and that kind of thing of the asset. So the question becomes, with a PPLI policy, the assets of the PPLI policy are also going to be relevant for you to, when you're going to onboard them, you're going to need to onboard those assets, do due diligence in relation to that, and in relation to the ongoing management. You're going to have to consider, are they good investments to have in the round? I don't think you can just say, oh, I have an insurance policy and that's the end of it. I think you'll have to look through that insurance policy to see what you've got.
Yes, I think that the major message there is, if you're going to have the trust holding the policy and not be a beneficiary to start with, then you're going to have to tailor-make the trustee obligations with respect to the investment responsibilities going forward. And you can do that. Obviously, you can draft that in. But if you just use an ordinary precedent deed to do this, then you might well find the trustee in a position of oversight, having to think about whether or not this policy is actually right for the trust and also right for the beneficiaries, particularly if beneficiaries start to clamor for distributions and start to require some level of support, they'll start talking about, well, can't we just surrender it? Or can't we just do things with it? So I think this one requires some intervention to make sure that the trust documents are actually fit for purpose as a policy holder. And that's probably the main message that comes across. So when we have the insurable event, we obviously have the transfer across to the trust of the underlying company shares. We've discussed the process and procedure for this before. The taxation effect. From Michael's perspective, if we're transferring across a normal PPLI policy into a trust, regardless of whether or not it's Indonesian connected, what's the tax effects of that, generally speaking?
I mean, it's really going to depend on the jurisdiction where the owner is located and how that would be viewed. Singapore, no capital gains tax. Indonesia, different scenario.
Yeah. And then here, because it's a pour over, we don't necessarily have a strict set law as such, because it's pouring out of a policy. So the rules that you mentioned earlier about attributing income and gains and all the rest to the set law, how would that actually operate in this scenario? I don't know if you've come across it in practice.
Not in practice, but I mean, if we're thinking in an Indonesian context and the policy is held within the trust, whilst the trust would be looked through, the policy itself is not a CFC, so you would get that deferral.
But then when it pours out, when it actually transfers from the policy into a trust, and then we're into a trust environment.
Oh no, that's what I was thinking about. If it's sitting within the trust environment and you've got an Indonesian set law, the policy is not a CFC. So whilst the set law, you're looking through the trust, you're seeing then a PPLI policy, so you wouldn't have an attribution in that situation.
Okay. I mean, from the CRS perspective, you'll have the usual thing. It depends on whether or not the trust is an investment entity and it's reporting will react accordingly. So looking at it from when you've got it actually into the trust, I won't run through this, but it's basically the same considerations that come up in any trust scenario. If it's a valuable company with valuable assets, you have to think about the overall governance framework within which the trust will operate, and not just a precedent document in all cases. And here you may look at protector committees and the ways in which beneficiaries can interact. So now this is the final example, a policy beneficiary. And in this case, we don't have a class of beneficiaries. Instead, we have a trust. And so the questions that come up in this is, what type of trust is this? A pilot trust, or is it going to be a pour over trust? How is that set up? Is it up and running alongside, parallel with the policy? And then what are the trustee obligations if they're just a beneficiary? And insofar as the policyholder is concerned, are they concerned about the beneficiaries at all? What's their obligations? Can they just get on with life, surrender, have the policy at risk as in the usual way? Is there any interrelation or any difference? Because now we have a beneficiary that's a trust. So from the perspective of the trustee obligations, I'll invite Marcus. If the trust is simply a beneficiary of the policy, it doesn't hold the policy, it's just there as effectively a pour over device. What are the obligations now as against what we said previously, where the trust actually is the policy holder and it's an asset of a financial asset of the trust?
Yeah, now we're into a much safer territory for the trustee. So, as a beneficiary of the policy, you don't have any absolute obligations. You will at some stage benefit, but effectively, it's a if you like, it's a standby in terms of the obligations. So you have rights as a beneficiary, but very little obligations.
Right. And looking from the policyholder perspective, Peter, obviously the policyholder can just get on and do what they were doing beforehand without any consideration of the beneficiaries. Is that the correct analysis? They don't have any obligations.
Yeah, I think this is I think what's going to be the very common scenario going forward in many cases, because the policyholder is in this case is most likely to be the same person as the settlor of the trust. They want to achieve certain tax benefits, tax deferral during their lifetime with the policy. They may want to have assets that perhaps the trustee is not comfortable to take into a trust structure at this point, but they can place them quite easily under an offshore company into an insurance contract. And life goes on as before, but the policyholder has the benefit of knowing that after the life of the life assured, which may well be him as well, him or her, The assets will then fall into the trust. The trustees possibly will just distribute the unwanted assets and maybe continue to manage the financial assets and follow the existing terms of the trust for future generations. It could be an existing trust. It could be a standby trust. And I think the food for thought for trustees is whether they want to be in the business of providing standby trusts. Becomes a business decision for such situations. So I think there will be quite a few situations like this coming.
Okay, I think looking at the transfer across, same issues that come up, the same issues as we mentioned in the previous. I do reiterate that if the trust has significant value, you will need to think about governance controls and some level of sophistication after the policy is has paid out. So we shouldn't just watermark this as once the policy is paid out, we sort of wash our hands of the client journey. Obviously, they then go into potentially a very sophisticated system, and we should consider that at the setup as well. So looking at the two, I think basically we feel that beneficiary, having the trust as a beneficiary is a little bit safer from the liability risk and a little bit more straightforward. Having the trust as a policyholder brings with it, unless you draft in and you create some bespoke provisions here, this creates more of a risk level for the overall profile of this sort of combination structure. But it seems that, and from what Peter's saying, that the future for PPLI and trust combinations is really where the trust comes in as a beneficiary and sits alongside. The only issue that we have when we have trusts coming in this way is until we have the insurable event, we are burning away our perpetuity period. If the trust is perpetual, then that's fine, we don't really care. But if it's 100 years, it's like, for instance, with Singapore, and we've, let's say, waited 30 plus years for this to occur, we've burnt up quite a lot of the perpetuity period. So that would be the only sort of overriding consideration if we're using a jurisdiction that still has perpetuity or trust period in effect. All right, so looking at the two, just some general comments now from us on this, and I think we can probably do it within the context of the question and answers as well. So what I'll do is I'll stop sharing on this, bring us all together. Looking at the sort of trust on one side and the PPLI on the other, what would we say on balance, looking at it from a sort of asset protection vehicle, or looking at it from the context of a succession vehicle, or something that can hold complicated sort of governance rules? How do we feel panel-wise this is all stacked up? Because from my perspective, the one thing I would say is the trusts seem to be a more stable platform for cross-generational planning, looking into beyond second, into third generation. Whereas I would say from a policy perspective, it confers a lot, it's a lot more deregulated. From the CRS perspective, it's much more straightforward. From the taxation perspective, it seems to be much more straightforward from the Indonesia side as well. So I would say that the trust is provides a more, this is from my personal opinion on this, and of course we can all chime in. I would say the trust provides a little bit more longevity and stability in terms of if you are structuring multi-generationally going forward. However, looking at the policy, it has, because it's contract-based, it provides a lot more deregulation, a lot more sort of tax benefits than the trust platform. So I think that would be the balance that I would say. What would any comments from Peter on this when we do the overall assessment of how these things stack together? Sorry, Peter, you're on mute.
Some people say I'm best on mute, actually. Overall, it's the combination, I think, that is incredibly powerful. I think if you're in the common law world, the combination of a trust with PPLI, if you're in the civil law world, a combination of a foundation with a PPLI, incredibly powerful to combine the merits of both. And I hope that's food for thought for some of the attendees today.
Any comments, Marcus, from you on hearing out the comparison?
I agree, actually. I mean, it's fair to say that you know, as common law lawyers, we tend to only think about the trust solution, and going forward, the combination solution is very neat, particularly during the lifetime of the set law, when there are issues that are arising that are clearly of frustration to the set law. That issue of how much the needs to supervise the assets, for example, and sort of meddle in it if the settlor thinks that way. These sort of things are easily dealt with the PPLI kind of in the insurance approach. But from a knowing perspective, you're thinking about successive generations, the trust really comes into its own. So that idea that the trust is a beneficiary of the policy, I think is a very tidy one.
Some sort of general comments, and I'll come back to Michael on this that we missed on the taxation side, but just some of the comments. Obviously, a policyholder can be a company. That's quite sort of common. Is that right? That we have an assignment. Obviously, a company can't be the originating policyholder. Is that right? It has to be an assignee. Is that correct? Or Yannick, is that not the case?
Sorry, the company can be a policyholder.
Yeah, but
absolutely.
Does it have to be an assignee?
No.
It can just be of itself, right?
Company straightforward, yeah, can be the policyholder.
Can we change the beneficiaries? So the nominated beneficiaries, once it's up and running, could we sort of change our mind that we want to have different beneficiaries going forward?
Yeah, absolutely. Anytime, as long as it's not an irrevocable beneficiary clause. So if you have a revocable beneficiary clause, the policyholder can change it anytime, as many times as he wants. And if you have an irrevocable beneficiary clause, you can still change it, but then typically the irrevocable beneficiaries, they need to agree and approve the change.
Right. And what happens where we have a policyholder pass away? If they're the one in the driving seat with these with the PPLI. What if we don't have a policyholder? Then what happens?
A policy would be an asset in the estate of the deceased. If the policyholder is not the life assured, then the policy would be continuing, and the policy itself would be an asset in the estate.
Yeah, but so what would, because we've got the policyholder having a level of control. How would that work if the policyholder is not around? Would it then be that you basically end up with a sort of mechanism that becomes more closed?
Typically, you can decide, and that's actually a very important point, if the policyholder is not equal to the insured person. You can, in most policies, you can decide who should basically become the policyholder once you pass away, because as Peter rightly said, otherwise it's the estate. And I've seen cases where this has not been clarified, and then you have kind of 8 people becoming the policyholder, typically the whole estate, and then they need to do all the decisions together, which can become very difficult. So it's crucial to decide and nominate somebody who takes over.
Michael, from your perspective, looking at the new changes that are likely to be put into effect through regulation, what's the main takeaways that we can say from the insurance market in Singapore? What's the main things that you would want people to take away from this?
Maybe before touching on that, just wanted to make a couple of quick comments on the combination structure and the comments that Peter and Marcus just made. I agree with, completely agree with in terms of, and yours, Zach, in terms of the trust. I think one point I just wanted to note is, I mean, when you look at the rules and how they might apply on a single location basis, that's one thing. But more often than not, you can have family members in many locations, and just to note that the focus is not so much are there advantages, but then to make sure that no beneficiary, depending on the jurisdiction, is disadvantaged. So for instance, you've got Australian beneficiaries. There's a penalty if you don't have a current year distribution. So how do you deal with that to make sure they're not disadvantaged? The other, and I think this ties to the question you're asking, is that the exemptions in Indonesia and the exemptions elsewhere will typically rely on a direct receipt of those proceeds. So if it's received into the trust, you're not going to then be able to avail of those domestic exemptions. More broadly in terms of the developments in Indonesia and subject to the detail around in the implementing regulations. I mean, I do think it's interesting. Generally, in terms of this conversation, the bite in the CFC rules to date, and bearing in mind 18 months or so ago, they were reformed to make them more effective in terms of being able to go down sort of lower tier CFCs. The reduced attribution, and depending on how the dividend reinvestment works, I think such that you can that would lead to an exemption. I think that's really interesting. Subject to the conditions around that, and also subject to the conditions around that reinvestment in terms of how long does it have to be reinvested in Indonesia. Yeah. What sort of instruments does it need to be reinvested into? But I think the starting point in terms of thinking about that would be the approach they took with the tax amnesty and the conditions around sort of repatriation and getting the lower penalty rate under the amnesty. The flip side, the change in the exemption for insurance, it still would be applicable if you've got to pay out on death. I mean, in the interim, you'll still get deferral because the PPLI policy is not seen to be a CFC, but you do need to weigh, balance those out, depending on the specific objectives, of a specific, family. And I think, that's always the key, is really understanding all the relevant sort of, details and objectives, not just around tax, and you don't want, the tax tail wagging the dog, but, at least understanding, what it means and, what the outcomes would be.
Right. And then the implementing regulations are due in February next year.
Yes. Yeah, the implementing regulations typically have to be issued within 3 months of the law being signed into effect by the president, and that start date was the 2nd of November this year.
Right, and presumably Deloitte, you guys will be doing an update when it finally comes in.
Yeah, yeah.
Right, okay, all right. Right, I think that's pretty much it. I'd just like to thank you all for spending time contributing to this and sharing your thoughts. As I've said at the beginning, the admonition is obviously these are general considerations. This is not designed to be or sort of constitute any legal advice. And please, if you wish to contact the panelists afterwards, please do. We will circulate the slides as well as the recording. The slides will contain their email addresses, so you can get in touch offline and going forward. So that was it. That's the last virtual roundtable for 2020. Look forward to seeing you guys into the new year. And just thank you, Peter, Yannick, Marcus, and Michael. Thanks very much, guys. And thank you for everyone for staying on board and watching this and being patient with us. It's now 1 hour, 40 minutes. So that's exceptional. Thanks very much, guys. See you in the new year.
Bye.
Thanks a lot.
Thank you. Cheers. Bye.